welcome to the Zoning Board of Appeals. We've got a long agenda this evening, so I hope you bear with us. First on the agenda is some housekeeping items. Need a motion to approve a charge to WB Mason for office supplies for $50.22.
Motion to approve?
Second?
Second?
All in favor?
Aye.
Aye.
So moved. Motion to approve charges to the Telegram and Gazette for June 28th, 2021 and July 26th, 2021 legal notices for $896.
Motion to approve?
Second?
Seconded?
All in favor?
Aye.
So moved. Thank you. Okay, for our first 6:30 hearing. This is a continued hearing from our July 26th meeting. And this is to hear the appeal of Adam Kahn for a special permit to Section 4B to construct a deck on a pre-existing non-conforming dwelling. Mr. Kahn, welcome. Welcome back, I should say.
Thank you. Good evening, everyone. How are you guys?
Proceed.
So, last month, so this is a proposal for adding a new deck that is 10 by 16 feet on the northwest side of our house, which is located on 27 Grace Avenue. So we discussed like some of the details last time when I had proposed like a plan that showed like like 2 feet between the neighbor's lot and from the edge of the deck. So one of the recommendations that we got was to get the certified plot plan, which I have submitted to the town. I do also have the copies here. So based on the survey, it's 2.5 feet, which is again like a half feet more when compared to the previously proposed plan.
Okay. Any discussion on the board?
As I disclosed last meeting, I do know the neighbors, so I'd like to just disclose that again.
Excuse me, Madam Chair.
Yes, please.
We do need a Mullins letter
Thank you.
for this
Thank you
case.
for
I hope it is
reminding
not
me of
too
that.
late.
Yes.
I have the number.
We are going to ask Mr. Fullen to step in for Mr. Nesbit. Mr. Fullen, do you have your Mullins letter? Thank you.
No, Madam Chair, it's actually, Patrick is going to be filling in now.
For
that
Matt Armenti.
Matt Armenti could
Thank
not
you.
attend today, and we'll have to also acknowledge to the applicant, get his signature.
Thank you. Do you understand the Mullins letter?
No, this is the first time I'm hearing about that.
Okay, here we go. Mr. Fullen was not at the last meeting, so he's required to view the hearing from the last hearing, which he has done, and that letter attests to that.
Okay, awesome.
So, thank you.
So could,
You need
Mr.
to
Fullen
sign
has
this
to
there.
sign it, and then the applicant also has to sign it.
You already signed it,
I did.
correct?
Okay.
Mr. Khan, could I ask you for your signature, please? There we go. Thank you.
Thank you.
Okay. I'd like to open this up for comments by the board.
And just to be clear, Madam Chair, signing that Mullins had nothing to do with Mr. Nesbitt's comment, which is just that he knows the neighbor, and he does not have to recuse himself from the hearing just because he knows the neighbor.
Thank you.
Yep. So, Madam Chair, I have a question
Sure.
for the appellant. Thank you for the plot plan that now shows the edge of the deck will be 2.5 feet from the property line. I usually have an issue with things that close to the property line. I don't have too much of an issue with garages or things like that, but a deck, I do. So I just want to know if you considered a 8 by 16 deck instead of a 10 by 16 deck.
So we talked about that. I mean, if we do by 8, it's gonna be like too short. I would request like 10 by 16. I have like a small daughter, and as you can see on the lot, we don't have any space to have like a social gathering, and we are like pretty open. Like our neighbors are like we don't even have fences, and I will be also adding railings around the deck, so that we are not like intruding or we are not like disturbing the other neighbors. But our neighbors, we have like 3 lots, like pretty much we don't even have fence. Like more, like all our kids are in their neighbor, like in their yard, and their kids are in our yard.
So, Madam Chair, I'll just respond to that.
Sure.
As I said last hearing, this is just me.
Sure.
As I said last hearing, the current owners of all the 3 houses might think this is a great idea, but we also have to think about future owners and protecting those properties. There currently is no fence, but if there was a fence put up, then you'd only have 2.5 feet to get things in between your deck and the fence. So that's the only comment I have at this time. Thank you, Madam Chair.
Any other board members?
I guess I would just echo that 2.5 feet is very close. I see what you're saying about the
Yeah.
building already being very close to the line, at the closest point being just about 10 feet, so it doesn't leave you a lot of room.
Right.
And did you, I'm not sure I followed the answer. As far as the deck being 10 by 16, did you look at making it shorter than 16? Because even just going back a little bit from the 16 would pull it further away from the line. I mean, if it was like 3 feet, honestly, I'd feel better about it.
So I just spoke to the surveyor. So the other thing, if you see, the shape of this lot is like a pie shape. So it's not like exactly like 2.5 feet like all along the like the side. So it's just the corner. So even if in case if you go 14, even if in case if we shorten by 14 feet, we won't gain much. It'll be still like almost like the same.
Yeah, negligible, in other words.
Yeah.
Okay.
So the other side, if you see, like on the other side of the corner, you have like almost like 5 feet there.
Right.
It's just the shape of that, the lot is like a pie shape.
Yeah, and it's sort of a double whammy, because it's pie-shaped, then the houses are going this way.
Yeah,
So
exactly,
it's,
yeah.
kind of a choke point.
Mr. Nesbit, comments?
No, I seem to echo the same comments as the previous 2 members, so I don't have anything to add.
Mr. Fullen?
I'm good.
Okay. And I think I would, again, question the size of the deck. It feels big and close. That would be concerning to me. Can you just repeat the size of the deck for my purposes?
Sure, it's 10 feet by 16 feet.
Okay.
And Madam Chair, one more comment. So I'm hearing a 10 by 16 would be preferable by the appellant, and if you look at the plot plan, the appellant can't shift it farther back into the pie, if you will, where there might be more room, because there is it's only about it's hard to tell, 3 feet connector, if you will, between 27A and 27B, and the deck would obstruct it. So I just wanted to hear the appellant's thoughts on making it more narrow to be, no matter what, it will not be within the 10-foot setback. But I was hoping for perhaps 3, but right now it's 2.5 feet, not 1, not half a foot, but 2.5 feet.
Okay. Any other comments on the board? Ms. McAllister, any comments? Okay, thank you. Being that this is a public hearing, is there anyone that wishes to be heard on this matter? Okay. Can I get a motion?
I make a motion to approve the special permit for 27A Grace Avenue and Residence B2 to construct a deck on a pre-existing non-conforming dwelling.
Can I get a second?
Second?
All in favor?
Aye.
So moved. So moved. Congratulations, Mr.
Thank
Khan.
you. Thanks a lot. Thanks a lot, guys.
Janet Circle.
Oh,
Do you need this?
no, it's point.
I don't know which order everything is
Point is
now.
next, and you gotta
Okay.
sign that.
Thank you.
Just need 1 second to shuffle through our drive. When did we first hear that, May?
June 28th, I believe.
Just need your signature, Patrick.
Could it have been May? Here it is.
Thanks.
Okay, next up, we have a request for a continuation on the hearing for, no, this is the wrong one.
I'm sorry, I thought you said.
Excuse me for a minute. Point Farm.
Oh, thank you. I will make a motion, Madam Chair. I make a motion to continue the appeal for a comprehensive permit modification at 526 Hartford Turnpike, otherwise known as Point Hills Farm.
Thank you. Can I get a second?
Second?
All in favor?
Aye.
So moved. Thank you.
Where is
That's okay.
that? Now this one is next.
I believe we'll have to ask the applicant about the Mullins as well. The Mullins will also apply for this one, for this upcoming one.
Oh, thank you.
We'll have to ask.
Ahead of time. Okay. I better open it.
It's already open.
Talking about 2 Janet Circle?
Yep.
Haven't opened it yet. We just did Point Farm?
Yeah, go ahead.
Okay.
When you open. So there you go.
Thank you. Next up, we have a continuation to hear the appeal of Michael Hopkins of 110 Lake Street, Shrewsbury, Mass. For an appeal to the Town of Shrewsbury zoning bylaws under Section 7 due to traffic, parking, size of structure, and a project not in keeping with the neighborhood at 2 Janet Circle in the resident B1 district. The subject premise is described on the Shrewsbury Assessor's Tax Plate 33, Plot 283000. We do need a Mullins letter. Patrick, do you have your Mullins letter?
I do.
Attorney Sladen? You, of course, know what a Mullins letter is.
Yes.
Thank you.
Do you want me to sign it?
Could you sign it for me? And-
Maybe the applicant, if you don't mind.
Okay. Got a lot of paperwork here.
Now, I'm gonna just hold on to all the signed things here till the
Oh,
end.
good idea.
Okay.
Okay. Okay, so we have a continuation. I'd like to first ask Attorney Madaus if he could please, as our town council, bring us up to date on a brief overview of,
Madam Chairperson, I don't mean to interrupt, but I do think there's a point of order here that needs to be put on the record. Since the last hearing on July 27th, I did file a memorandum with the town on August 3rd, and I properly served it through the Zoning Board of Appeals staff email. The memo was signed by me. It had my complete signature on it with my office's address, fax number, and email address. This afternoon at 4:30, I received a packet that was filed with the town on August 20th, and I haven't had proper notice, so I'll be objecting to any of these proceedings going forward on behalf of Whitney Street Home Builders. I just want to put that on the record at the start of this hearing. It should have been served to me. I'm the attorney of record for the appellant. I did not receive a copy of these pleadings. All my contact information was on the memorandum that I filed, and there's a memorandum that was submitted to the town in response to my memorandum, which means that whoever submitted this had my contact information, and this project already reeks of impropriety, and now the appellant has been denied his right to respond appropriately and substantially to the allegations in these pleadings. So I just want to put on the record that this was improperly done and it's completely prejudicial to my client. before we get started.
Thank you. Attorney Madels?
Thank you. Through the chair, at the last public hearing, the question was presented to me whether a provision of the town's zoning bylaw is applicable to the proposed use at 2 Janet Circle as reflected in the building permit. And the provision in the bylaw is the definition of family, which reads, any number of persons related by blood or marriage living in the same dwelling, and that's an important distinction, I might point out, any number of persons related by blood or marriage living in the same dwelling is a family, or not more than 5 persons unrelated by blood or marriage living together as a single housekeeping unit, but not including a group occupying a boarding house, club, fraternity, or hotel. So the question presented was, is that zoning provision applicable to the proposed use as reflected in the building permit? And if it is, does it create a zoning violation? And so I researched this matter relative to 2 realms of jurisdiction, if you will. One, the Fair Housing Act, because the building permit application was supplemented by a number of letters from different affiliates of the applicant representing the use as a program, and the letters all mirrored similar content or were verbatim of one another, and they wrote that the program is not required to be licensed by the Massachusetts Department of Public Health, and the letters describe the training, rehabilitation, and educational services that will be available to participants in the program, the availability of individual and group therapy sessions, and the educational components of the residential facility. And it was represented in a letter from Tricord Transitional Housing, Inc., that all participants must abide by the program rules, which include, but are not limited to, 1, attend work, education, training program, attend education, counseling, and therapy groups, no use of alcohol or drugs, consent to drug and alcohol testing on an as-needed basis, and abide by the good neighbor policy. Finally, in a letter to the building inspector from Whitney Home Builders dated August 18th, the proposed use of the property was described as an, quote, 8-bedroom sober house. So what's important about the use is it would qualify under the Fair Housing Act as a residence for disabled persons, because as we talked about in the prior hearing, under the Federal Fair Housing Act, it protects disabled persons from discrimination in housing, and it includes within that definition those who are seeking sobriety from drug or alcohol addiction. Those that use illegal drugs are not deemed to be disabled persons. They would not qualify for the protections under the Fair Housing Act. So knowing that it's residence for disabled person under the federal law, and I should also note that the Federal Fair Housing Act mirrors protections of the Americans with Disabilities Act. But for this analysis, I just adhere to the Federal Fair Housing Act, which when we encountered this issue, Board Member Mulcahy asked if there was a case on point, because I couldn't answer the question as to whether the local zoning provision falls away, if you will, with the protections of the Fair Housing Act. There is, and I know both parties, I think, have cited it, the Edmonds case, a U.S. Supreme Court case, Edmonds v. Oxford House, where the city of Edmonds sought to enforce its limitation on the number of unrelated persons living together as a zoning provision. And under the Fair Housing Act, there is an exclusion from its effect of local, state, and federal restrictions regarding the maximum number of occupants permitted to occupy a dwelling. So Edmonds sought to, made the argument that its zoning regulation fit within that exclusion to the Federal Fair Housing Act. The Supreme Court Judge Ginsburg rejected that argument and said that the zoning provisions are subject to the provisions of the Fair Housing Act, What's not subject to fair housing is like our state building code occupancy ratings based on square footage. But, and I could cite the language in there, but the desire for a family-type residential district is subject to provisions of the Fair Housing Act, not subject to the exclusion. So that set me on this path of, under the Fair Housing Act, if a proponent of a protected use is entitled to what's termed to be a reasonable accommodation. And a reasonable accommodation is just what it sounds like, which is to create an exception or adjustment to a rule, policy, practice, or service that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling. And refusing to grant a reasonable accommodation to a zoning or land use ordinance may be discriminatory if the requester is entitled to that accommodation under the Act. So the question becomes, what is a reasonable accommodation? And the Fair Housing Act provides that so long as the accommodation does not require an undue financial and administrative burden on the local government, or it would not fundamentally alter the local government's zoning scheme, the accommodation must be made. And so when I reported this, I have to say that since the hearing, we received a written request for a reasonable accommodation from the proponents of the residential structure, detailing their argument that they're entitled to it. And they wrote in their letter, the sole accommodation being requested is that the proposed maximum number of unrelated residents be increased to 14. The requested accommodation does not increase the total number of individuals permitted by right under the zoning bylaw, as the zoning bylaw permits occupancy by, quote, any number, end quote, of related individuals and up to 5 unrelated individuals, i.e., as written, the zoning bylaw already permits occupancy by 14 or more individuals. Therefore, the requested accommodation does not undermine the zoning scheme in any significant way and does not change the residential character of the neighborhood. The proposed sober house will look like a single-family residence and will not generate traffic or noise that would be out of character for the neighborhood. Additionally, the requested accommodation will not impose any undue financial or administrative burden on the town. Again, that was a quote from the letter requesting the accommodation. So when I contacted the building inspector about the request for the accommodation, it was reported that they've already been given a reasonable accommodation because that's how the building permit was allowed to be issued for the proposed use, and that she was familiar from continued training from Mass State Building Inspectors on the Federal Fair Housing Act. And I should say that, one of the things I discovered is some towns have implemented procedures for determining reasonable accommodations so that one employee isn't confronted with it themselves and put in a tough spot, but that you would have a procedure adopted to deal with these in the future. So we're confronted with the fact that a reasonable accommodation has already been made. The applicant subsequently requested a reasonable accommodation on the number, claiming it would not undermine the zoning of Shrewsbury. And subsequent to my research and my memo to the board, a case came out of a U.S. District Court in Texas where the city of Plano had denied a request for reasonable accommodation on exactly the same issue. And with a really extensive analysis, the court found that the accommodation should have been made under the Act and awarded costs to the plaintiffs. I don't want to get too far afield on all of that and all the detail from a district court case out of Texas. But that issue is before this board, that the building inspector made a reasonable accommodation, and the applicant has requested it, and the provisions of the Federal Fair Housing Act give you that test as to whether it must be granted. But secondly, and perhaps as important, we have, of course, in Massachusetts, the Dover Amendment, which is, the Dover Amendment is language in Chapter 48, Section 3, that provides, in relevant part, that no zoning bylaw shall regulate or restrict the use of land or structures for educational purposes on land owned or leased by a nonprofit educational corporation, provided, however, that such land or structures may be subject to reasonable regulations concerning the bulk and height of structures and determining yard sizes, lot area, setbacks, open space, parking, and building coverage requirements. Now, in all the letters that the building inspector received, the applicant cited the Dover Amendment, and they subsequently identified Tricord Transitional Housing, Inc., which is a nonprofit corporation, as the intended lessee of the property. And the program, under Massachusetts case law, which our SJC takes a broad interpretation of educational uses. And just, for instance, training of life skills to disabled persons is deemed to be an educational use. It's not limited to academic curriculum, which kind of surprises and in some instances disappoints people, but that is how our court reads broadly the educational protection of the Dover Amendment. So separate from the Fair Housing Act analysis of whether they're entitled to a reasonable accommodation, I think with what has been supplemented for the application, with Tricord being a nonprofit educational corporation, I have their articles of organization here, and I cited it in the memo. Provided they will carry out the program as represented, the use would be protected from use restrictions in our bylaw. And so then that question is the definition of family a limitation on the use rather than a dimensional constraint? We can apply reasonable dimensional requirements on Dover Amendment protected uses, and there's an inquiry for that as to whether the dimensional or bulk restriction is requirement. Not so for use restrictions. We may not regulate the use. And I view the definition of family as limiting the number of unrelated persons that may live in a dwelling as a use restriction. So I think under the Dover Amendment, the restriction of family may not be applied to the protected use. And I think that may have aided the building inspector's initial determination for issuing the building permit. Now, all that being said, I know that's anticipatory of the use has not commenced. And this, as was stated at our prior hearing, the building as presented on the plans does not show any, did not need any relief from our zoning requirements as a single-family residence. It is permissible dimensionally. One could build a house with 8 bedrooms in this zoning district, and we don't limit the number of parking spaces. So the violation would, if one were to occur, would be if this applicant does not in fact execute the lease with the qualified nonprofit educational corp, or does not conduct the program as represented, then they wouldn't have the protections of the Dover Amendment. But as they have represented it to the building inspector at the time they applied, I think the building inspector was within her jurisdiction to make the determinations. And again, there was no evidence of a zoning violation, nor would there be one until an occupancy occurs. And then they have to establish all those elements to support that it's not subject to enforcement of the limitation on unrelated persons. I hope I didn't make that overly difficult, but.
Thank you. Thank you. We appreciate those comments.
Madam Chair, can I just, before the parties have a chance, just ask to clarify while it's fresh in my mind?
Sure.
Okay. So thank you for that, Attorney Medas. I think that was very helpful. I think I can speak for myself. I can't speak for everybody on the board. I know that we've all individually spent a lot of time thinking about this case and trying to understand it, and the sort of complicated regulatory structure that exists around this issue. And as I mentioned last time, we were all together here. I think our job on the board isn't to sort of substitute our own preferences, but it's to apply the law. And I think Attorney Madouse's memorandum was very helpful to me in terms of understanding the law. So to make sure that I have that right, though, what I'd like to do is maybe repeat back kind of what I think you're saying. And if you could just tell me whether I've more or less got it right, that would be helpful for me before we hear from the parties. So I think we can all sort of agree that based on the disclosure of the occupancy contemplated for the building that's subject to this permit, 14 people, that sort of on its face violates Section 2 of the bylaw in terms of not more than 5 unrelated persons living in a dwelling, right?
Yes.
But I think it's also appears to be clear that the use that's contemplated here is one that is protected by the Federal Fair Housing Act. And as a result of that, we are required by federal law to make reasonable accommodations to allow that use to take place. And I think what the proponent of the permit is basically asking is a reasonable accommodation to allow 14 unrelated people instead of 5 to live in this structure. And I think as far as meeting the test for whether that's a reasonable accommodation, the argument is that there is no significant cost to the town. And I would say from the record before us, I don't see any evidence of any cost to the town. And that it not fundamentally change the underlying system of the bylaws. And I think that's also true in the language that you highlighted here from Section 2 would allow any number of persons related by blood or marriage. So infinity persons who could fit in the structure within the building code and sanitary code and everything, if they were related, could live in this structure. And so, obviously they're not asking that. They're asking for 14. They're basically asking to be treated in the same way as persons who are related by blood or marriage would be, to enable more people to live there, 14 people to live there. I think we have seen in the record that in terms of the efficacy of group therapy, a group is required for that purpose. And so it seems to me that it meets that accommodation meets the test under the Federal Fair Housing Act. You also mentioned the Dover Amendment, and I think it does seem clear also based on your analysis that we have a piece of land that's owned or leased by a nonprofit educational corporation. Education includes sobriety, treatment, and education. And the question is basically whether the definition of family is a use, and that if we were to, does applying this definition of family effectively discriminate against this use? And I think the answer is probably that it would, because you otherwise would be restricted to sober houses, treatment facilities where people, to have that many people living there would have to all be blood relatives, which of course isn't something that's very likely to happen. So I think the sort of outcome of that, when you look at those two hurdles, is that you're looking at something that's protected by the Federal Fair Housing Act. A reasonable accommodation has been requested. The reasonable accommodation that's been requested arguably meets the test. And the Dover Act, or Dover Amendment, would also apply, and the use is at least arguably, the definition of family is at least arguably a use restriction that we might need to make a reasonable accommodation for also in this circumstance.
Yeah, my only point on that last item about
Please.
the use restriction is the Dover Amendment prohibits the regulation or restriction of the use. And so I don't even think there's an analysis required as to
Right.
whether it's unreasonable as applied. I think it's just prohibited.
You
from
can't
being
do it at all.
Correct.
Right.
Versus reasonable dimensional controls, you do that analysis. Does the limitation on the number of stories deprive the protected use of the benefit of the property?
Right.
And if it does, then you must accommodate them. Then it's not a reasonable dimensional. But a use restriction, I think, is, by the language of the Dover Amendment, not applied.
Yeah, and here to sort of drill down on it, how is the definition of family a use? That feels counterintuitive, but I guess the answer is that this many people, if they were all blood relatives, could live there, no question. And by defining family in the way that we've defined it, we're excluding this use, effectively excluding this use for the number of people that at least according to the record is required for this kind of therapy to be useful.
It's an occupancy restriction, and I view that as a use regulation.
Sort of per se, yeah, okay.
And so, thank you for all that. I don't know if you had any questions about that.
It was sort of a very long question. Do I have that right,
Yeah,
more or
you
less?
did it better than I did. The realization is we are constrained, imposed upon by federal law and state law. In fact, I think the state law in Massachusetts is almost more protective than the federal law. The federal law, we'd have to do that reasonable accommodation analysis, and there may be gray there to get to a result, but I think when you turn to the Dover Amendment, there's almost certainty there.
Right.
And certainly, I think the applicant is fully aware of the Dover Amendment based on the letters they submitted.
Right.
And I know there's been objection that there is no lease yet, which is required to, if it's not owned by the qualified nonprofit court, but I would expect that you don't enter a lease until you have a building.
Right.
So that would follow. But again, those elements have to be met post-completion of the building to not create a zoning violation.
Right. So, and the point, one of your last points there just raised another question, if I may, Madam Chair.
Excuse me, Madam Chair, I'm so sorry to interrupt. I just have a quick announcement that I would like to make to interrupt this. I've gotten news from the higher-ups that there's too many people in this room to not have masks. So if everyone would mind putting on their masks, unless you have a health exemption. I do. Then I apologize for the interruption. Thank you. We do have some.
We have a box.
We have a box up here. My apologies. Yeah.
No.
Everybody's getting masks on.
Can't, unfortunately.
Yeah, we're in the middle of
I'm so sorry. Yep, just hang tight if you don't mind.
I guess I'm not.
Much more?
I guess so.
Okay.
I just figure cover all the bases.
Okay. Let's continue.
Okay. And to the
Peter?
extent that anyone's worried that I've just been spraying virus out, I am vaccinated as I'm talking here. So my two follow-up questions, sort of briefly, you raised the question of the timeliness of this and whether this is really a ripe issue. And I know that the question of standing has also sort of been raised. I understand from what Attorney Sladen said at the outset that those papers regarding those topics, she did not receive them until 4:30 today. And so I would tend to agree with her objection to the extent that we received them weeks ago, I think, that those aren't really properly here, that would prejudice her client if we were to talk much about those. But I guess my sort of question is, I don't know that we even need to reach those issues if we feel like the bases that we've just discussed here sort of answer the question. Is that fair?
Yes, I agree with that.
Okay. All right, that's all from me for now, Madam Chair.
Thank you. I'd like to proceed with Ms. Sheehan. Is there anything that you could add as the building inspector in the town that would help us understand?
So right now, between what has been said back and forth, I think that it's been provided good information. It's all information that I've reviewed, and it's a good summary. So if you want to proceed, and of course, I would be able to answer any questions that may come up, for me.
Thank you. Attorney Sladen, I'm going to open it up to you.
Is it okay if I take my mask off while I speak, or do I need to keep the mask on?
I mean, given that everyone's masked now,
Everyone comfortable if I take it off?
Yeah.
Okay. I would just like to briefly respond to some of the comments that were made. I think this argument that the use is not relevant at this point in time, the use issue is put forward on the actual building application that was made. So it didn't ask what the use was on the application, but the applicant put it on the application, and they essentially put the cart before the horse. So it is before the Zoning Board of Appeals, and I think the use issue is the crux of the entire issue. I also think it's really important to remember the time frame that we're dealing with. The dates that we're dealing with are March 9th, 2021, the date of the application, through May 5th, 2021, which is the date the permit was issued. So all of these supplemental letters trying to correct a permit that was already issued is improper. We see here that there are people for special permits trying to have a deck built for 2 feet more than is allowed, and they have to delay a project for 30 days in order to get the appropriate permit. I don't understand why special preference is given to this particular project where they can violate the Shrewsbury zoning bylaw and not have to delay, and they continue to construct a building that is, right now as it stands, in violation of the Shrewsbury zoning bylaw. The last time we were before you, we asked for a stop work permit. It was not issued, despite the fact that as the permit stands on its face, it violates the Shrewsbury zoning bylaw. Now, with the Dover amendment, I agree that this proposed use would be protected as long as it is leased out to a nonprofit corporation. However, again, as the application stands on its face, as the permit stands on its face, it does not comply. The Dover amendment does not apply. So if we want to be anticipatory that this is something that, you know, they're going to remedy these things, I would ask you to look to all the other residents of the town that have to jump through hoops to get the permits that they require. The other issue here is that everything is after the fact. So we didn't have a nonprofit corporation at the time of filing. Now we do, because we submitted a letter saying that they're going to be involved. The Fair Housing Act, you know, that the restriction, we knew that we were going to have to give a reasonable accommodation. So we gave them a reasonable accommodation already. We were here at a hearing a month ago. All due respect to Machine, but Machine didn't say she provided a reasonable accommodation. This is an explanation after the fact because someone's been called out. As far as the reasonable accommodation being requested, I would certainly respectfully disagree that this doesn't alter the fundamental residential zone. The zoning, the area for the B1 for 2 Janet Circle is for single-family homes. The housing that's been suggested in the correspondence that's come back and forth from Whitney Street Home Builders, St. Jane Francis Homes, Tricord Transitional Housing, all suggest that this is somewhat transient housing. They could be there for 6 months. The residents could be there for a year. That absolutely alters the fundamental area of the town of Shrewsbury. This isn't something that this is going to be a long-term residential area. This is permanent housing for these residents. That would obviously make a difference, because in these communities we're building families, we're building relationships. These people are coming and going. Another issue as well is the Edmonds case. I would respectfully disagree with Attorney Madaus. I believe the Edmonds case, the Supreme Court suggested specifically that a local government may generally restrict the ability of groups of unrelated persons to live together as long as the restrictions are imposed on all such groups. So while I understand and appreciate the family argument, what do we now say to a group of 14 roommates who want to live together? They're not allowed to do it. The Fair Housing Act doesn't say that now we can have no restrictions whatsoever because they're disabled. What it says is that we have to treat the 2 same groups of people, and here we're talking about non-related persons, the same. So if we have a group of 14 roommates and we have a group of 14 persons who are in recovery, they both need to be treated the same. So I interpret the case law and I interpret the research that I have done to look at the issue that way. It's not whether this is a family or not a family, it's whether or not we're treating the same number of people the same in Shrewsbury. So if, again, a group of 14 people wanted to live at 2 Janet Circle and they didn't have this rehabilitation portion of the use, they wouldn't be allowed to do it. So is this a reasonable accommodation under the Fair Housing Act? I'd argue that the Supreme Court in Edmonds would say no. In that particular case, there was a suggestion in the dissent from the Supreme Court that the reasonable accommodation would have been from 4 people to 6 people. This reasonable accommodation that's being requested triples the number of people. The U.S. Census Bureau for the town of Shrewsbury from 2015 to 2019 had the average number of residents in a single-family home as 2.73. I don't know how we have a 0.73 of a person, but that was the average number of people within a home. This is 14 people in a residential single-family home. It's not absolutely not a reasonable accommodation. So I seriously hope that the zoning board will consider some of these arguments and take that into consideration when deciding this, because the cart was really put before the horse. And given the way that some of these things have been handled, I have concerns as a resident of Shrewsbury myself, and I just hope that the zoning board is looking out for the residents of this town, in addition to the contractors who try to work here. Thank you.
Thank you. Questions or Ms. Sheehan?
So I would like to answer some of the comments that have been made about whether or not the level of review prior to the building permit being issued was deemed reasonable accommodation. So again, going back to the chapter 40A, section 3, imposition of health and safety laws or land use requirements on congregate living arrangements among non-related persons with disabilities that are not imposed on families and groups of similar size or other unrelated persons shall constitute discrimination. So doing my due diligence with the letters that were given prior to May 5th of this being issued, stating that this is a nonprofit under the Dover Amendment, which is the section that I just read, that we reviewed reasonable accommodations and we reviewed imposition of health and safety. Health, meaning that we reviewed 105 CMR 410 for accommodations for sanitary conditions, square footage of occupants under the housing code, which is not something that's generally applied under the building permit for a single-family dwelling. Reasonable accommodations, living arrangements, sanitary conditions were reviewed. Safety conditions, means of egress, which is always reviewed for a single-family house, was again reviewed extensively with the fire department. So the fire department contacted the applicant and came to an agreement under the authority having jurisdiction that a residential sprinkler system would be added to this occupancy. So we did the review based on sanitary conditions, based on safety conditions, and based on the Dover Amendment with the information that was provided prior to the permit being issued. So that's what I'd just like to add.
Thank you. I'm going to open it up to discussion amongst the board. Ms. Cosette?
Sure, I'll try to speak there. I'm going to take mine off too. I'll try. My glasses are going to fog up as I speak, sorry, and I'm going to try to read. So my thoughts on this after hearing from opposing counsel and our town council, I don't agree that the building permit that was approved is in violation, I'll say that. It deviated from our local bylaws, but I do believe the building inspector viewed that as protected. So our local bylaws were superseded by state and federal laws. And I'd like to just point out, in response to a comment made by Attorney Sladen, anything that deviates or violates from a zoning bylaw that comes before the building inspector, it gets decided then that there needs to be an appeal for a variance or a special permit. So yes, you saw an appellant come who wanted to build a deck 2.5 feet from another property. That's because we have zoning bylaws about that. That person, that appellant, was a person without disabilities who was trying to build a deck or a pool, and that person didn't have federal or state protection. So every case is different. The application to build this sober house, though it did deviate, you would think, from our local zoning bylaw, was protected, I believe, and thank you, Attorney McDowell, for providing that additional documentation. And our zoning bylaws were superseded. So the building permit, when it was issued, would not have come before us. So it was approved, and now we're going through another process where a resident is appealing that building permit being issued, and here we are today. I will summarize a lot of what Mr. Mulcahy said as well. I do believe the building inspector provided a reasonable accommodation with respect to the number of persons based on the Fair Housing Act. That was before a request was made for that reasonable accommodation, because she knows what she's doing and is well-versed in all of this, and she checked. Once the use as a sober house commences, it will be protected by Dover Amendment, as has been explained to us, such that the zoning restriction will not be enforceable against the educational use by a nonprofit educational corporation. And I don't view the timing of this as malicious. I think things just play out this way. The appellant did not have a known tenant at that point, but always from the point of the application knew the intent of this structure. So that's all I have at this time, Madam Chair.
Thank you. Mr. Nesbitt?
I don't know how much more can be said than what's been laid before us in this meeting and meetings prior. Do I like the fact that information changed before or after permit issue, permit application? I don't, but where we stand and where all the information we have now, that's where I think our decision has to come from. And I think we've been given a lot of great information from everybody that's spoken to make a very informed decision to the best of our ability.
Thank you. Mr. Cullen?
I'll agree with that.
Okay. Right, and in order not to belabor what's already been a lot of information, I will just say publicly that all of us have spent a lot of time on this. And we've learned a lot about the reasonable accommodations, the Fair Housing Act, the Dover Amendment, and we've paid attention and read everything that's come in front of us, and I just want you all to know that there's been a lot of time and consideration given to this. That being said, I happen to think that we are constrained by both federal and state laws, federal housing and the Dover Amendment, and I don't think I could really say much more than what's already been said by my colleagues here. So let's move along to public comments if we could. Given that it is a public hearing, I am going to open it up to public comments, but I am going to say that we've heard a lot from a lot of people, and I would ask that if anyone does have a public comment, they could keep it to new information. I think at this point, that would really be helpful to us and to the process. So if there's anyone that wishes to be heard on this matter, I'd ask them to please step forward. Okay. All right. Can I get a motion to close the public hearing for 2 Janet Circle?
Motion to close?
Can I get a second?
Second.
All in favor?
Aye.
So moved. Can I get a motion, please?
I make a motion to sustain the determination of the building inspector to grant building permit R21-207 to allow the construction and proposed use of the structure at 2 Janet Circle.
Can I get a second? Okay.
Second?
All in favor?
Aye.
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 So moved.
Thank you.
Thank
Didn't
you.
hear from Mr. Mullen.
I say no.
Oh,
We have a no.
thank you. I'm sorry, I didn't hear you. Okay.
Madam Chair, I think
Yes.
town council might like
Yeah,
to.
Attorney Madaus?
if members could just state, I know you already did, but just for the record, reasons for your vote, just so we'll have it on the record, if you can.
Certainly. I will start by saying that I feel constrained by both federal and state laws.
Yeah, and I think I sort of laid out my thinking at the beginning. In a lot lot of detail. I would say, one thing that sort of stands out to me, I mean, as far as not caring about the people of this town, I grew up in this town. My parents grew up in this town. I went to Shrewsbury Public Schools. When I started my family, I moved back to this town with my daughter. If I didn't care about the people of this town, I wouldn't devote the time that I devote here or to town meeting. So I'm not sure that that's helpful. What I do see as helpful is that we try to guide ourselves with what the law says. And sometimes the law leads us to outcomes that we might not personally like or that might not seem fair, but our job is to try to do what we can with what we have. And I think in this case, it seems clear to me, based on the research that's been provided, that we really do have to provide a reasonable accommodation here. And I think, you know, as far as 14 roommates or something like that, I think the key distinction there is that 14 roommates don't fall into a protected class under the Fair Housing Act. And people who are trying to get sober education do. And that triggers a lot of protections that I think, you know, as we talked about in a previous hearing, many people in our community need those protections. And the law provides for them, and it's our job to enforce them in our community. And I think that's what my vote's based on. Thank you.
Thank you. Ms. Cosette?
I'm not going to repeat everything I said already, but I do believe this is a protected use. I think it's something all communities need. I believe the person who applied for the building permit is just developing a property in order to lease it to someone to provide this to our community. I wholeheartedly believe the building inspector looked carefully at this building permit and provided a reasonable accommodation to protect this use. And I believe we are forced to protect this development due to federal and state laws that supersede our zoning bylaw. And there's a reason for that protection, so that people aren't discriminated against. And again, we will have a chance to see if this development actually gets used as it was intended and represented to us. And we will see that when it is occupied and as a sober house as it's intended by a nonprofit educational corporation.
Thank you. Mr. Nesbitt?
Mirroring the same comments before, I feel hamstrung by state and federal guidelines, and that's the reason for my decision.
Thank you. Mr. Follen?
Yeah, I say no because I just, I find, you know, there's great arguments on both sides, but I think there's a lot of gray area. And I like what the attorney had to say today, especially, and that's just the decision I want to make for the particular motion.
Thank you.
Thank you all. Thank you for
Thank
your
you.
time.
Thank
Thank
you.
you.
Can you hold on to that, Lisa?
This is
Just get that.
just this one.
Yeah,
Does this go inside?
In between here, can I hit?
goes right in there.
Okay, these are both signed.
Yeah, 1 second.
Take a recess or
So we have to
something.
take so you'd have to ask for a 3-minute recess so that Patrick can use the bathroom.
I would
Okay.
support that.
Okay, we're gonna
No
take a
problem.
3-minute
Gotta
recess.
vote for it, I think.
Yes.
Can I
think
get
you
a
move.
motion, please, for a
Motion
3-minute?
to take a 3-minute recess?
Can I get a second?
Second.
All in favor?
Aye.
So moved.
I second that.
To the Town of Shrewsbury zoning bylaws under Section 6, Table 1, to construct an in-law apartment in the basement of a single-family dwelling upon property located at 29 Broadway in the Residence B2 District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 27, Plot 039000. Good evening.
Good evening, Louis Mignona. I'm the project manager with Castle Kitchen and Bath, representing David Casanelli. First off, it's good to see you guys in person. I think the last couple we did via Zoom.
That's right. That's right.
Anyway, so per Shrewsbury bylaws, it's required that any in-law apartment gets a special permit. So we're here today for that. The in-law will be enclosed within the existing structure, so we will not be adding on or anything like that. It'll be occupied by the parents who currently own the home, and their son will be moving into the main residence.
Our point of order, I just want to say that when I was announcing, I said Broadway, and it's Brookway.
It should be Broadway.
Broadway?
Broadway.
Yep.
Oh, so it's Brookway.
There's another Broadway.
Okay, thank you. Okay. Board members.
So there's no change to the footprint. This is all inside. I have no issue. I wish this was just allowed.
Agreed.
But there will be a condition that we specify a blood relative,
Yep.
and it will sunset
Yep.
with the property. No issues.
Okay. Any other board members? Mr. Nesbit, Mr.
No.
Pullen?
None for me.
Okay. Being that this is public hearing, is there anybody that wishes to be heard on this matter? Okay, can I get a motion to close the hearing, please?
Motion to close?
Can I get a second?
Second?
All in favor?
Aye.
So moved. Can I get a motion?
I make a motion to approve the special permit for 29 Broadway, Residence B2, Section 6, Table 1, to construct an in-law apartment.
Can I get a second?
Second?
All in favor?
Aye.
Aye.
So moved. Thank you.
Thank you very much.
You're welcome.
Thanks. So I don't have the legal notices in front of me, so I'm just winging it on the motions. Is it fine? All righty.
Doing good. We get an A so far? Peanut gallery? Yes. Okay, here we go. Okay, next 6:30 hearing is to hear the appeal of Stone Creek Development Corp., 552 Main Street, Unit 6, Shrewsbury, Mass., for a special permit to the Town of Shrewsbury zoning bylaws, Section 6B, to construct an addition to a pre-existing non-conforming dwelling upon property located at 911 Park Street in the Resident B1 District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 22, Plot 098000. Good evening.
Hi, good evening. Good to see you
State your
guys in
name for the
person
record.
this time.
Right.
So it's a pre-existing
Can you
non-conforming.
state your name for the record
Oh,
for us?
Daniel Benoit,
you,
Stone Creek
Daniel.
Development. So this situation is a pre-existing non-conforming. The front porch sits in the new setback. It is 22 foot 6 inches, and the setback currently is 30. So the pre-existing non-conforming, the addition would be 10 feet off of the back of the house and staying within all the setbacks and not encroaching on any other property lines.
Thank you. Can I get a comment from the board? Ms. Cossette?
I'm just confirming that the changes are not becoming more non-conforming, so I don't have any issue with that.
Mr. Mulcahy?
Same, I'm just trying to get the plan to load.
Yeah.
You have it up already? It's spinning very slowly for me.
So currently the house is at 15 foot off the property setback, and then the addition would put it at 12.5, stays within the 10.
Within the 10, okay. Okay, that's all I need to know, thank you.
Mr. Nesbit?
Nope,
I
I'm
don't
good.
know why we get these.
Mr. Fullen?
Good.
Okay. Being that this is a public hearing, could I ask anyone that wishes to be heard in this matter to step forward? Okay, being that there is none?
Oh, we got one.
Oh, there
We
is.
do. Oh, thank
I-
you.
To the mic.
Curious, how far will the
Can you
addition,
state your name and your address for the record?
David Como, 40 Holman Street, and I'm just curious how far the addition will be from the back property line?
Looks like it's 86.5 feet.
86 and a half, yes.
86.5 feet.
Okay,
Well within the setback.
yep, thank you.
You're welcome. Anyone else wish to be heard on the matter? Thank you.
Motion to close?
Motion to close?
Second.
Great, thank
Aye.
you. All in favor, aye?
Aye.
So moved.
Okay.
Can I get a motion?
I make a motion to approve the special permit for 9 Park Street in the Residence B1 District from Section 4B to construct an addition on a pre-existing non-conforming dwelling.
Can I get a second?
Seconded?
All in favor?
Aye.
So moved. Thank you very much.
Thank you for your time, have a good night.
Thanks.
Did I need to say 9 to 11 because the application was changed?
So
It's a weird property.
it
Yeah.
is 9 to 11.
We can
Okay.
revote just for the sake of it if you want.
I made a
I don't know.
Yeah.
That's okay.
Scrivener's error.
We could do a Scrivener's error.
I sent you
Thank
this
you.
email earlier.
Yes,
If you want,
I-
you can have a hard copy.
I love the
Sure.
Scrivener's error.
Yeah.
It comes in handy.
Yeah.
It does come in handy.
Okay.
And the one that they make you sign and say, I forgot to sign this. You'll come back and sign again. Okay. Next 6:30 hearing is to hear the appeal of Fred and Jan Gonzalez, 8 Heatherwood Drive, Shrewsbury, Mass. For a special permit to the Town of Shrewsbury zoning bylaws, Section 4B, to construct an addition on a pre-existing non-conforming dwelling upon property located at 8 Heatherwood Drive in the Resident B1 District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 11, Plot 182000. Good evening. Could we get your name and address for the record, please?
Sure, good evening. I'm Fred Gonzalez, 8 Heatherwood Drive.
Thank you.
So we wanted to put an addition to the rear of our home, and went through the process and found out that we're in a non-conforming situation with the front of our house, front yard setback. The rear addition would be conforming. So we're here to apply for a special permit for the front yard setback.
Okay.
Sorry, just pulling it up.
Sure.
Okay. Comments? Ms. Cossette?
I'm sorry you have to go through this. What you're doing is not making anything more non-conforming.
Yeah.
So I have no issue, sorry.
Mr. Mulcahy?
Same here.
Mr. Nesbit?
Same.
Mr. Follen?
No, looks good to me.
Great, thank you very much. Being that this is a public hearing, does anybody wish to be heard on this matter? Okay, thank you. Can I get a motion to close the public hearing?
Motion to close.
Can I get a second?
Second?
All in favor?
Aye.
So moved. Can I get a motion?
I make a motion to approve the special permit at 8 Heatherwood Drive in the Residence B1 District to Section 4B to construct an addition on a pre-existing non-conforming dwelling.
Can I get a second?
Second?
All in favor?
Aye.
Aye.
So moved. Thank you
Okay.
very much.
Okay, thank you.
Good evening.
Other two?
Hang on, I won't take that. All right. Next 6:30 hearing is to hear the appeal of Andrew Sarabian and Joanne Sarabian of 55 Elm Street, Shrewsbury, Mass. For a special permit to the Town of Shrewsbury zoning bylaws under Section 4B to construct an addition on a pre-existing non-conforming dwelling upon property located at 6466 Elm Street, Shrewsbury, Mass. In the Residence B2 District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 32, Plot 002881. Good evening. Please state your name for the record.
Thank you, Madam Chair and members of the board. For the record, my name is Richard Ricker. I'm an attorney with offices at 11 Maple Avenue, and I'm here with Andrew Sarabian, who's the homeowner. And this is very similar to the other special permits you've been listening to tonight. The house is non-conforming. I told Andy he could do this himself, just for the record.
I could cut my lawn myself, too.
He can cut his lawn himself, too, he says. But, as you can see from the plot plan, he wishes to put a small addition on the front of the house facing Elm Street, and he wants to put an addition on the rear of the house. Neither one of those adds any nonconformities. It's all within keeping. This is a prime non-conforming structure because of the side yard setback, which is not being increased. So I would respectfully suggest that it's in keeping. It is not posing any nuisance or any other harm.
Thank you. Comments from the board? Ms. Cosette?
So this case is slightly different than the others. It is more non-conforming, but it's well within the side yard setback of 10 feet, so
Madam,
I have no, yes, go ahead.
I'm sorry, maybe this is a question that I would like to ask the applicant through you, but is this a two-family
No.
structure?
Well,
It is.
it's being changed to a single.
Well, it's still going to have the other, we're keeping the.
Oh, okay.
Yeah, it's going to be below, if you, it's on that plan.
So that is fine, it continues to be a two-family, but
Yeah.
the setbacks do change for a two-family. And so it is, I believe it's 30 in the front and 30 on the sides, 50 in the rear.
But regardless, it's still,
But
it's
regardless,
already
yeah,
non-conforming, so
it's
that's
all
my point, it's not
non-conforming, so
making it more.
But it is a non-conforming addition, so to speak.
Right.
Can I just clarify what you said there? Because it's, sorry, two-family, what is the side yard setback?
Let me pull it up for you.
And I'm looking at it
So
It's
right
It's
now.
only more non-conforming on, looking for the compass rose here, on the south side.
South.
Yeah.
From 22.1 to 15.2.
Right.
But the 15.2 would be,
Exactly.
isn't, right. So it's still, that
It's
part's
still
not within the
within.
building envelope, but.
It still doesn't encroach on the 10-foot
Right,
setback.
right, exactly. Well, but I think Rowan's point is that it's not a 10-foot, it's a 30-foot for a two-family, but
in the zoning
because this is a existing structure,
So
it's,
you're still protected under a
Yep.
special permit.
yeah.
Just a point of clarification.
No, thank you, that helps. Mr. Mulcahy?
Nothing from me.
We do have elevations if you needed to see them.
Mr. Nesbit?
No, I'm okay.
Mr. Fullen?
Good.
Okay, I'm okay as well. Being that this is a public hearing, is there anybody that wishes to be heard on this matter? Sir, please state your name for the record.
Paul Bianchi, 63 Elm Street. I live directly across from this house. I was very happy to hear that Andy had purchased it, and looking forward to him fixing it up and making an enhancement to the neighborhood.
Great.
So I hope you find it in his favor.
Thank you.
Thank you,
Thank you.
thank you,
Thanks, Paul.
very helpful. Anyone else wish to be heard in the matter? Okay, can I get a motion to close the hearing?
Motion to close?
Can I get a second?
Second?
All in favor?
Aye.
Aye.
So moved.
Madam Chair, I make a motion to approve this special permit for 64 to 66 Elm Street in the Residence B2 District for Section 4B to construct two additions on an existing non-conforming dwelling.
Can I get a second?
Seconded?
All in favor?
Aye.
So moved.
Thank you very much.
Thank you very much.
Can you get me signatures on that? That's a point form. Okay, thank you.
Is it just one sheet?
Yep. Okay. Next 6:30 hearing
Request for continuance?
is to hear the appeal of Martha Gannon, 29 Park Street, Shrewsbury, Mass., for a special permit to the Town of Shrewsbury zoning bylaws under Section 4B to construct an addition on a pre-existing non-conforming dwelling upon property located at 29 Park Street, Shrewsbury, Mass., in the Residence B1 District. The subject property is described on the Shrewsbury Assessor's Tax Plate 22, Plot 103000. Could I ask you to state your name for the record, please?
Yes, good evening. My name's Tom Marcello. I'm with TCI Construction. I'm here representing the homeowner, Martha Gannon. And basically what we're looking to do is a master suite addition on the far right corner of the property, which will not make it any more non-conforming in any way.
I'm sorry, what's the address of this? Sorry.
This is
We're out of order. We're going out of order, so I'm
29
so
Park Street.
confused. 29 Park, okay, thank you.
29 Park, yeah.
correct. Thank you.
Okay.
We've had a couple on Park Street tonight, thus the
Yeah.
confusion. Rowan, anything to add?
No, I don't think so, Madam Chair.
Okay. Being that this is a public hearing, is there anyone that wishes to?
Another question.
Oh, go ahead.
So I'm looking at the plot plan, and maybe it's just the way I'm looking at it, I feel like I'm not understanding. It says proposed addition, then there's an arrow to a structure that looks like it's part of the existing building? I just want to make sure I understand which part's the part that is actually being
which-
added. Sorry, I don't know.
The plot
There's a
plan, the
couple arrows on there, on the,
Under
So
proposed
you got
addition?
proposed addition under it, it points to it looks like it's pointing to the one that says existing. So is the addition the 28 by 28?
correct,
Okay.
correct.
All right, so it's
There
just
was a different addition
misplaced
done,
arrow.
prior, I think
I
about
see.
6 or 8 years ago,
Okay,
and, that did not require a special permit at that time,
okay.
but that's what that is, yes,
All right. So the addition's completely within the building envelope.
it is.
Great, thank you.
Ms. Cosab?
Again, it's not becoming more non-conforming, so I don't have any issue.
Mr. Nesbit?
I'm good as well.
Mr. Fullen?
Looks good to me.
Okay, thank you.
I'm gonna need help with reading the motion,
Okay,
however.
open the
I'd
public
make a
hearing.
motion,
We
oh,
have to open the public hearing. Anyone wish to be heard on this matter? Being that there is no one, may I ask for
Would you like
a,
me to make the motion?
motion to close the hearing?
thank you, can I get a second?
Seconded?
All in favor?
Aye.
So moved.
I'd like to make a motion for 29 Park Street, Residence B1, to construct an addition on a pre-existing non-conforming dwelling.
We'll do that next.
Hate to steal
Have to go
Patrick's
first?
thunder. I think the waiver request should go first.
So,
Oh,
sorry, but
you'll
we
have to do it again after we do the waiver request.
We have a waiver request, this is a two, so, might I ask Lisa to ask for the waiver request, and then we'll let you,
Hey, I was just trying to help her out.
you're doing
Or
great.
you could do
Thank you,
that.
you're doing a great
So
job.
is the waiver request for plot, it wasn't for plot plan, because we have a plot plan.
Yeah, we
No,
have-
it is. It's
Yep.
not a certified.
Sort of not
Oh,
certified,
okay,
it's not
sorry.
stamped.
Oh, okay, now I understand what happened here. This makes more
Interesting.
sense.
Didn't catch that.
So the 28 by 28 part was drawn on on an existing plan,
Yeah,
and that's why got it.
okay. But the addition is totally within the footprint,
Yes.
second story addition, okay. Okay, so I make a motion to approve the waiver of plot plan for 29 Park Street.
Can I get a second?
Seconded.
All in favor?
Aye.
Aye.
So moved.
You want to do this again?
Yeah.
I make a motion for 29 Park Street, Residence B1, to construct an addition on a pre-existing non-conforming dwelling.
Can I get a second?
Seconded?
All in favor?
Aye.
So moved, thank you.
Thank you. I believe I have the next one too, so.
Okay, well, you
Okay.
can just sit right there, and we'll get you to you in 1 second.
I wasn't going to vote for it, but the way that Patrick read it, it
I
just
know,
spoke to
it's
me.
very compelling, Patrick. I don't have a second sheet on this, in case I need,
A second vote sheet
yeah, on a
for
waiver.
a waiver? No.
This
we
is
don't
for
do
you.
No,
that.
okay, just checking. Yep.
Need that.
No, it's okay, just give me that. All right. All right. Next hearing is to hear the appeal of Ann Conahan, 17 Brookway Drive, Shrewsbury, Mass., for a special permit to the Town of Shrewsbury zoning bylaws under Section 4B to construct an addition on a pre-existing non-conforming dwelling upon property located at 17 Brookway Drive in Shrewsbury, Mass., in the Residence B1 District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 23, Plot 0340000. Can I ask you to state your name for the
Sure,
record?
yes. Tom Marcello, TCI Construction, here with the property owner, Ann Conahan. And she is the owner of 17. It is existing non-conforming. We're looking to do an addition off the back of the property, which will be a bedroom, and that will not make it any more non-conforming. We're also looking to slide the garage up. Part of that garage, existing one-car garage, will become the bedroom. So she's looking to still have a garage, so we want to slide that up. Excuse me, and do a garage towards the front, which will be just over 12 feet, along with a mudroom, that's going to be 8 feet. So that will bring us in just under the 10 feet at the left front corner of the property, to the side yard setback.
So the,
Madam Chair, may I
Yes.
jump in? Just to
Yes,
clarify
please.
for the board members, we did receive a certified plat plan
Yep.
late last week, so take a look at that one for the most final.
And so again, the existing nonconformity here is to the east, the 7.1 feet. What was the previous setback, the existing setback on the west side of the property?
The west side was, I don't have it on the plot plan, as you can see.
Yeah, it becomes
like a little
9.3,
angle.
but.
You know,
Yeah,
it's,
9.3.
the
Yeah.
back part that shows existing is a shed that's gonna come down. And I think that was right at 10 feet, but
Okay.
obviously I don't know the exact.
So it's becoming slightly more non-conforming, but very close to the line, less than a foot from the.
Yeah, I think it's about 8 inches there.
Okay.
Ms. Cassette?
It's actually becoming less non-conforming.
More.
Because he took,
More non-conforming.
Sorry, yeah, more non-conforming, which is great, and I'm sure it'll be a major improvement. So I have no issue.
Mr. Nesbit?
I'm good. Even though it's less non-conforming, there's less linear footage that's gonna be non-conforming than what's existing.
Mr. Fullen?
I'm kind of lost on here and people saying less non-conforming,
Yeah,
that
I
I
know,
see it's
so-
gonna be more non-conforming.
Yeah.
Yeah, that was,
My point was there's gonna be less linear square footage or less linear surface area that's gonna be non-conforming than what's existing.
Because he's
Currently.
cleaning up the lines.
So even though the garage is being pulled up, but the bedroom and back is gonna meet that setback. But where it's, the building's constructed now, there's more area of house.
so, Mr. Fullen, I'm in error. The existing house is non-conforming. With the addition, it will still be non-conforming. It will just be further from the rear property line.
Further
Which
from
is
the rear, but closer to the
Western,
western side.
Yeah, but not by much.
Not by much at all.
Very minimal, so.
Tiny.
Minimal.
And single story, very much in keeping with the neighborhood.
Yes.
So I don't, no
Yep.
issues with the
Yep, it's
visual.
gonna remain one story, yes.
Okay. Everybody good with comments?
Yep.
Being that this is a public hearing, is there anybody that wishes to be heard on this matter? Okay. Can I get a motion to close the hearing, please?
Motion to close?
Can I get a second?
Seconded?
All in favor?
Aye.
So moved. Can I get a motion, please?
Oh, boy, and I don't have, I'm gonna need help on that one. Thank you. I don't know why none of the pertinent information printed on my copy. Where are we?
I'd like to make a motion
Yeah,
for
thanks.
17 Brookway Drive, Rural A, to construct an addition on a pre-existing non-conforming dwelling.
Thank you. Can I get a second?
Seconded.
All in favor?
Aye.
So moved.
I'll let you know when I don't have the
So
info.
moved. Thank you. Congratulations.
I have it on some, but not on others.
Yep, that's it. How are we doing so far, everybody?
Right on
Alive
time
and
for the
well.
7 o'clock hearings.
Okay, it's about 12 o'clock in the middle of the night, and we're almost there. Okay. Wow, okay. Next up, these are 7 PM hearings, and the next one is to hear the appeal of John Power, 40 Drexel Street, Worcester, Mass., for special permit and variance to the Town of Shrewsbury zoning bylaws under Section 4B and Section 7, Table 2, to remove and replace a pre-existing non-conforming dwelling upon property located at 246 South Quinsigamon Ave, Shrewsbury, Mass., in the Resident B2 District. The subject premise is described on Shrewsbury Assessor's Tax Plate 45, Plot 860000. Can you please state your name for the record?
Hi, Jay Gallant, Gallant Architecture, working with John Power, owner of the property.
Thank you. Would you
So-
like to describe the project for us?
Yes, please. So there's an existing house on the property that was built in 1900, been in Mr. Power's family for many years. And recently, the house directly behind it, 246A, was removed and rebuilt by their son through a similar process and came out nicely, I think.
Outstanding.
Just about ready to move in.
They moved in last week.
Perfect, all right. So now they'd like to follow a similar process for the existing house at 246. So a small lot, the existing house is non-conforming as you stated. The only property line where the existing house doesn't encroach on the setbacks is I guess it would be the north side. And our proposed house will still not be closer than 10 feet on that side. Everywhere else, it's already non-conforming, and we're increasing non-conformities, but providing a nicer house for the area. Not sure what else to say about that. It still works pretty well and makes for a nice, I guess, complement to the new house that was built behind it and the adjacent houses that have also been rebuilt or changed significantly recently.
Okay, thank you. Ms. McAllister?
Thank you, Madam Chair. Just to point out to the board that we did request an updated proposed plot plan showing the rear yard setback as measured from the proposed deck, rather than the proposed end of the house, so to speak. So that rear yard setback is measured at 6.7. So just to keep an eye out for that. And then procedurally, they did apply on their application for both a special permit and variance, I believe. A variance is not required in this case, Madam Chair, so I would ask that the applicant withdraw without prejudice at the time before the vote.
Wonderful, thank you. Board members, questions, comments? Mr. Mulcahy?
Sure. So I had but lost the proposed plot plan. Oh, it's back.
Yeah.
And there are kind of a lot of lines on it. And I'm, which is a silly thing to say about an architectural drawing, but I'm having a hard time understanding what is what in terms of property line versus right-of-way. So I understand obviously that this is the proposed new house. Is the property line this easternmost?
Are you working off the same drawings that he's showing? So
This might be more
perhaps turn it
clear.
around, and if you could.
Yeah, it'd be easier to see if you could.
Better than looking at a little screen on your
Right.
tablet.
So,
So the property line is this dark black line.
is the dark one.
The red line is the proposed house, the yellow line is the existing house. The right-of-way is, just adjacent to the property.
Right,
And
and
it's actually, it goes with the 246A.
Okay,
The
so
only way
it's,
they can get to the street from their house.
but so it's a formal right-of-way, it's recorded and all that kind of thing? Okay.
Yes, right? I mean, it's part
When
of
they
the
sold the
property.
house with the, put the addition up, the pool and everything,
Mm-hmm.
it was landlocked, so.
Yeah. Okay. I just wanted to make sure, because I suspected, and it looks like I'm interpreting this correctly, that the corner of the proposed house would be a foot from the property line. But if that right-of-way is protected and goes with the property and continues to exist, that shouldn't be a problem, because no one can build on it. So it's functionally as though the property line is further away in reality. Okay, that's helpful for me.
And for the record, the existing house is also 1.1 feet from the same right-of-way.
Okay, the one I'm looking
Right.
at doesn't have the, I'm in the wrong document, maybe. Doesn't have the existing one. Okay, here we go. Next one. Okay, yeah, so it doesn't matter anyway. Great.
Ms. Cosette?
Can I just confirm what Ms. McAllister said? Sorry, Rowan. So there's a special permit and variance before us, but this will be just a special permit that we'll be approving.
Right, so
They applied in error.
they
Okay,
checked both boxes in their
Okay.
application. This is kind of typical, but all the setbacks that are increasing are already non-conforming.
okay. But you mentioned the proposed deck on this proposed site plan. There's a 15.3 foot number, but does that go to the house? Or did-
Correct.
Okay, so to the deck, it would be, you mentioned 6 feet,
6.7.
6.7 feet.
And that plan is labeled as updated in your updated proposed plan.
Oh, thank you.
In all
Well, let me
caps.
find
Yep.
that.
Want to come back to you?
Yeah.
Mr. Nesbit?
I don't have any further questions, no.
Mr. Fulham?
I think it looks awesome.
All right.
I like it.
Stamp of approval from Mr. Fulham here.
That works.
That's all you really need.
It'll be great to have the both houses be
Yeah.
similar.
Lisa, any more
Nope,
questions?
I understand the change now.
Okay. Being that this is a public hearing, is there anybody that wishes to be heard on this matter?
We have a letter from a neighbor, if it helps. Should I
That is,
bring it
is it
forward?
in the,
No, I don't believe we.
if you'd
got
like
ahead
to,
of time.
if you'd like to give it to us, we'd have to keep it in our records, but,
Become part of the record, yeah.
Should I give it to you?
sure, please.
And you can read it.
What's the address of this neighbor?
It's on there, I believe.
This is from Kelly Moody at 244 South Quincy Ave.
Correct. Thank you.
So it's in the butter.
Generally in support, or?
That says it all.
Okay.
Says you're making a huge improvement to the property, and they fully support it. Okay, can I get a motion to close the hearing?
Motion to close?
Can I get a second?
Seconded.
All in favor?
Aye.
So moved. Can I get a motion
Yes.
to withdraw the variance?
Don't
Yeah.
sign that yet.
Don't sign it yet.
Well, you have to vote yet.
I make a motion to withdraw the variance without prejudice for 246 South Quinsigamon Avenue.
Can I get a second?
Seconded.
All in favor?
Aye.
So moved.
I make a motion to approve the special permit for 246 South Quinsigamon Avenue in the Residence B2 District for Section 4B and not sure if Section 7, Table 2 applies anymore.
That was on their
Okay,
application.
so, Section 4B, to remove and replace pre-existing non-conforming dwelling.
Can I get a second?
Seconded.
All in favor?
Aye.
Aye.
So moved. Congratulations.
Thank you.
Good job. Thank you. Okay. Next. Okay, hearing number 10. This is to hear the appeal of Robert Lundgren of 166 Walnut Street for variance to the town of Shrewsbury zoning bylaws under Section 7, Table 2, to construct a single-family home with a non-conforming side yard setback upon property located at 35 Hartford Turnpike, Shrewsbury, Mass., in a limited business district. The subject premise is described on the Shrewsbury Assessor's Tax Plate 57, Plot 047000. State your name for the record, sir.
Jim Lundgren.
Good evening.
I'm representing my brother for this project. It currently is an existing non-conforming building on the property. If you see the Jarvis land survey we had done, this house, just a little bit of history, was built by a family almost 100 years ago. At that time, Lakewood SIG was much lower than it is. Through the string and dam that was built over the years, it put the flood zone really close to existing conditions. So we're looking on replace the existing house with a new one. We want to go to the upland side of the lot. So in order to do that, there's already a non-conforming side on the right side where the garage is. If you see what we've sent over from Jarvis, we're looking to move it to the back side of the lot. It would not be creating any of the non-conformities on the other setbacks. It would be actually creating a better one. Currently, it's 4.7 feet off the line at the right bottom corner, and this would be 5 feet off that line. And it would allow the house to be constructed up on the upland side of the lot. The buildings there was built in the early 1900s. It's substandard construction. We would rather replace the entire structure. And also with the topographical conditions, we wouldn't be able to use that existing building as it sits now.
Thank you. This is a public hearing. Well,
The board.
sorry. I'm sorry, I'm getting a little tired.
I know.
I'm tired. Ms. McAllister, anything you'd like to add?
Just to point out to the board members that this is in the limited business zoning district, so the setbacks are 15 feet on every side, except for on the frontage for Hartford Turnpike, that's 50. So it's just a bit unusual from what we normally see. And I would just mention that that the existing garage, yes, is 4.7. It is detached, making it not part of the structure. So the setback of the dwelling itself is larger than 4.7 as existing.
I'd just like to add that we met with the Conservation Commission and to work with them and comply with they request to have the house further away from the lake. If we didn't get the variance, we'd have to move closer to the lake and to the water, and we're trying to comply with their recommendations on this project also.
Thank you, that's good information.
Very helpful.
Thank you. Comments from the board?
Sure.
Mr. Mulcahy?
Great presentation. Just want to make sure I understand. It's becoming, the proposed house is slightly closer to the lake than the existing house, but it's further uphill.
Yes, sir.
No, okay, great. That's all I need to know. Thank you.
Ms. Cosette?
I'm fine. They've demonstrated hardship for me,
Okay.
and this will be an improvement. That's
Mr. Nesbit?
I'm good as well.
Mr. Fullen?
I agree with that, a hardship with the topographical and all that, and I have no problem.
Great. And I too agree, and thank you for that extra information with regard to the Conservation Commission. It's very helpful. This is a public hearing. Anyone wish to be heard on this matter? Okay. Can I get a motion to close the hearing?
motion to close.
Can I get a second?
Seconded?
All in favor?
Aye.
So moved. Can I get a motion?
I make a motion to approve the variance for 35 Hartford Turnpike in the Limited Business District, Section 5, Table 2, to demolish and reconstruct a new non-conforming single-family dwelling.
Can I get a second?
Seconded with the amendment that it's Section 7, Table 2.
Oh, what did I read?
5.
Oh, I said 5, sorry. Yes. So
Second.
moved.
Second.
Thank you. So moved. All in
Oh,
favor?
Aye.
Aye.
Thank you, so moved. Okay, thank you,
Thank you very
congratulations.
much.
Thank you.
Thank
Have a good
you.
evening.
Okay, next up, we have a hearing to hear the appeal of Esso Design Collective LLC, 19 Depot Street, Uxbridge, Mass., for 2 variances to the Town of Shrewsbury zoning bylaws under Section 7, Table 2, to construct an addition with a non-conforming side yard setback and front yard setback on a dwelling upon property located at 116 Boylston Circle, Shrewsbury, Mass., in the Resident A District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 10, Plot 014000. Good evening.
Good evening.
Can you state your name for the record?
Yes, I'm Stacy Oliva with Esso Design Collective, and I'm here with Paul and Kristen Blutis, the owners of the property. We are proposing to attach a 2-car garage to the current home. The house was built in the 1947, and it currently has a freestanding garage with an attached carport that we believe was built around the same time as the house. The home, that current carport sits about 6 feet away from the side yard setback. The house is also within, there's a buffer zone that runs halfway through the house, the 100-foot buffer zone from the wetland area behind the home. So we propose to attach the garage to the house north, in front of an addition that the homeowners put on in 2011. The 27.3-foot relief is actually to the front edge of the proposed porch that we're hoping to connect the main front door to the garage. And the front wall of the actual foundation of the garage should be at that 30-foot mark of the front yard setback. And in doing so, we are, as I see it, decreasing the nonconformity of the side yard setback in that the existing freestanding garage is about 6 feet and we're increasing it to 9.1 feet at the back corner.
Thank you. Ms. McAllister?
I just will call the board's attention to a supplemental document we received showing the wetlands, the location of wetlands on the lot as requested in the comment letter. So, thank you.
I could also comment that we haven't been in front of conservation yet. I had instructed Paul and Kristen that I thought it might make better sense to come in front of the zoning board first to make sure that everything seemed copacetic. When they put the addition on back in 2011, they went in front of the Conservation Commission because the addition was much closer to the wetlands, and they were granted at that point. So I'm expecting we'll be in front of them again, should the board approve the variance.
Okay. All right. Comments? Mr. Mulcahy?
Sure. So, for a variance, the requirement is a hardship. That's something unique about the soil, shape, or topography of the land. Here, I take it that what creates the hardship here is you have this drainage easement that really encroaches on that north side, so you couldn't possibly fit a garage there. And you have the wetland coming up, you said 100 feet from the rear yard setback, and so that kind of limits you there. So you're sort of hemmed in on both sides by things that are outside your control and are probably more unique to your property, at least, than the others around. So am I sort of stating the case for the variance?
Absolutely.
Okay.
We sort of looked at that location as being the least impactful to the property, both from the wetlands perspective, obviously the easement, and it sort of blends architecturally, the idea of the house, the garage, it just is a much more aesthetically pleasing home to look at.
Sure. Okay, that's all I need to know. Thank you.
Thank you. Ms. Cassette?
I'll just summarize, you're becoming, less non-conforming on where you're placing the garage, the new garage, and you're kind of just taking a little bit of that and putting it towards the front of the house for the front porch. And I imagine that is one of the points of egress to the house, and you're just providing.
Correct.
There'll be a roof over that?
There's
or will it just
actually,
be a?
the point at 27.3 feet, there is no roof over that. That just allows for the 3-foot landing at the front door, and then it connects over to the garage roof. So that area within that front yard setback, the roof will be within the front yard setback.
Okay, wonderful. Thank you. I have no issues.
Mr. Nesbit?
So that front piece of deck, I believe you just mentioned is just 3 feet, it's just for code landing?
Right.
Okay, thank you.
Mr. Fullen?
I'm good.
Thank you. I'm good too. I think the design's beautiful.
Yeah, that's great.
Very nice, very nicely done. Okay, it's a public hearing. Is there anyone that wishes to be heard on this matter? Okay, no one wishes to be heard. Can I get a?
There's only one public left, so.
There's three.
Oh, no, you guys are.
They don't live on our street. I know that.
Phew, right? Thank goodness.
I had to look quick. You used to.
All right, can I get a motion to close the public hearing, please?
Motion to close.
Can I get a second?
Seconded?
All in favor?
Aye.
So moved.
I make a motion, that looks like there's two
Yes.
variances, okay. I hope I can read it this way. I make a motion to approve two variances for 116 Boylston Circle in the Residence A District, Section 7, Table 2, to construct an addition with a non-conforming side yard setback and front yard setback. Okay.
Yes. Can I get a second?
Seconded?
All in favor?
Aye.
Aye.
So moved.
Thank you.
Congratulations.
Thank you so
Enjoy
much.
it.
Time.
All right.
Alright, one left.
Okay. Next public hearing. Wow. Okay, number 12. To hear the appeal of James Bishop, 160 Gulf Street, Shrewsbury, Mass. For a modification of a variance from the Town of Shrewsbury zoning bylaw under Section 5F to allow for 2 single-family dwellings on one lot for a temporary period of time upon the subject property at 160 Gulf Street in the Residence A District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 09, Plot 011000. Good evening, state your name for the record.
Jim Bishop, I'm the owner.
Thank you, Jim. What can we do for you tonight?
Looking to extend the variance that I had. Need a little bit more time. The only thing I'm lacking is the asbestos survey, which he'll be here next week, the beginning of next week, to do the survey. And once I get that survey done, I can get the asbestos removed from the siding's asbestos, and I have a couple of pipes downstairs that are asbestos, so I have to have that removed, and then I can tear the house down.
Ms. McAllister,
Yeah, I
please,
can.
background here.
Yeah, this one's probably a little bit unusual for the board. In 2018,
2017.
2017, the board allowed Mr. Bishop a variance to have two single-family houses on one lot, so I believe it was so that he could reside in one while the other one was built.
That's correct.
And so, one of the conditions of the decision, and you can see the original decision in your file, there was a condition there was 4 conditions, but the specific one that is seeking modification is that the existing single-family structure cannot remain beyond 45 days of the issuance of the temporary CO. That 45-day period passed in August, and Mr. Bishop filed the appeal to stay the fees and come back before the board for an extension, and that would likely be reflected also as a condition of the decision in a similar way to the previous decision here.
Okey-doke. Comments from the board?
That last part. So the condition would read?
So it's, and the board can decide how they want to do
Yeah.
it. But it could be that you could condition it in a similar way that this original decision did, and instead specify, I believe that the appellant is asking for 60 days, 60 days from, and again, maybe I would ask the board clarify when that 60 days starts, for clarity of the decision, but it could potentially be a condition of your decision or simply a modification.
Okay. Let me just.
Thank you. Comments from the board? Mr. Mulcahy?
Yeah, so, so you said it's next week that the asbestos abater will be coming.
Correct.
When were you thinking the 60, I guess I want to make sure that you have enough time to do it all.
As soon as I can get the permit,
Yeah.
I would like to get the 60 days from the time I get the permit. But I have everything in for the permit except for the asbestos survey.
Okay,
That's
but
the only thing I'm waiting for.
you think that the house can be knocked down within 45 days from the issuance of the permit, though? Or 60, whatever it is you're asking for?
60,
60?
yes.
That,
Yes.
okay.
And all that's lined up? You have someone to
Yes.
do all of that?
Yep.
I guess the reason I ask is I'd rather grant like 90 days to make
yeah.
sure you have enough time to do
Yes.
it than have you have to come back before us
That would be
again.
great too, but,
Yeah.
I was,
I think that's a fair, given where we're at with contractors and such.
Yeah,
That's
I don't know
fair.
how much time is likely, that's kind of what I'm trying to get at, like,
Yeah.
I think,
And I'm gonna have the building power shut off, next week too.
yeah.
Okay.
So the power will be shut off to the building, and I'll do a work order for the electrical to be removed and everything next week. So it's not like anybody's gonna be in that dwelling.
Yeah, I'd just rather do it once and have you comply with it than do it part way and have you have to come back or not comply with it.
Yeah, that would
You
be
know,
great.
so whatever the amount of time is that makes sense for that. Others on the board know better than I do how long that'll take.
So I'd just add to that, the reason you weren't able to stick to the 45 days is because of COVID and construction
Pretty
costs. I
much,
mean, everything,
yes,
and the impact
yes.
it has just rippled.
Yep.
That hasn't changed too much. So
might get worse.
despite your lining up everything, you could still run into trouble. But you'll have the asbestos certification or whatever, and the fact that you're gonna be shutting off power, certainly, you wanna do it.
Oh,
You're just
I want
asking
it
for
down.
more time. So I would be amenable as well to the 90 days, or I'll just leave it
Attorney
at that.
Ricker, I believe, said that you could give him up to 6 months.
That's what the bylaw allows.
So 90 days is 30 days, 3 months.
And from a construction standpoint, if I could just mention that.
Well, we can ask for public comment, because he's
Public comment.
here.
Hey, you're
Hold
public,
that
right?
thought.
I don't have any further
Mr.
comments.
Nesbit, Mr. Fullen, do
Excuse me?
you have any questions, comments?
I do not.
Okay. Given that this is a public hearing, might I request some public feedback?
Thank you, Madam Chair, members of the board. If I was him, I'd be asking for the 6 months, because COVID's coming back. I mean.
Yep.
Yeah, in the fall.
It is
and, he could very well, run into difficulties with not just the permit process, for getting through the ultimate goal that he has, which is get rid of the old house.
Yeah, right.
It's not like he's gonna rent it. or
With no
for
electricity.
6 months.
And no pipes on
So
the
I would think,
side.
I would think if I was him, I'd be asking for the 6 months, no more than 6 months, because that's what's allowed.
Right.
And that way, he's got a cushion that will mean he doesn't have to come back here again.
Yeah.
That makes sense.
And once you're over the hurdle of allowing extra time, I'm not sure it makes a big difference to give a little bit more time.
No, right, and we're talking January.
Okay?
And yes,
But-
you're talking with the conditions.
Oh.
Yeah, Madam Chair, may I
yes,
just
please.
clarify, I just want to make sure I'm following here. I do want to make sure that the start of the 90 days has a finite start. Or the
Yes.
6 months, excuse me, rather than
Yeah.
the issuance of a building permit, which
Oh, I see.
is indefinite, so to speak, or at least.
So I would,
Bylaw
just
says,
gave him-
bylaw says it has to be from the date that the initial permit ran out.
Which is,
August 3rd.
3rd,
So we can do
Well,
6 months
so
from
starting
then.
from August 3rd and
Well,
give you
let's hear
180
what-
days?
Rowan.
I'm not sure if I'm following, to be honest, but
February 3rd would be 6 months.
Yeah.
Okay.
from the 45 days of so August 3rd was the passage of the 45 days since the issuance of the temporary CO.
Right.
So 60 months, I don't think it's 6 months after that 45. The 45 days is just
Oh, I see.
given
Oh,
by
I
the
see.
board.
So it's by August 3rd minus 45 days, whatever that is?
Yeah, that'd be my understanding.
Okay, so what's that?
All the more reason.
Someone do the math.
We could just say August 3rd,
From
3rd,
the-
2021
Like
minus
June
45 days. We have
Oh.
to do the math.
We could do that.
No, I'll calculate it.
We could do that. Give us 1 second.
Be
For us to-
December, about like December 18th, it would run out.
What is that, June 29th?
It's a June,
I think it's that last Tuesday in
So
June.
June 19th, 2021.
29th.
June 29th.
By the 29th, it'd be 45 days before the 3rd, or before August 3rd.
Yes, because the 45 days was temporary, right? Is that what we're,
Right, so
That
45
was
days
just the
back.
condition.
is that
From
kind
August
of like a
3rd.
grace period?
So, sorry.
That was just something written in the condition, 45 days.
So I get December 19th, 2021 is
That's what you
six months from
The 18th.
45 days before August 3rd, which is a really complicated way of getting there, but we got there.
So December 19th, okay.
Which is a Sunday.
Okay, so let's do Monday, the 20th?
That
Okay.
would
Would we
be-
have to go back?
Yeah, we have to go back because that's the maximum.
Yeah, that would,
Okay, so we have to go back to the
17th.
17th.
So the 17th.
Okay, so first I need to get a motion to close the public hearing.
Would the
Motion
one
to-
remaining member of the public who hasn't spoken like to speak?
No, I'm not, I'm good.
Can I get a motion to close?
Motion to close.
You don't
Okay,
want
Can I
my
get a second?
Seconded?
All in favor?
Aye.
Aye.
So moved. Can I get a motion?
All right, who's doing this one?
I think Peter should.
Like it's
December
zero.
17th is the day.
Yeah, so it's, right. Move to approve a modification of a variance for James Bishop, 160 Gulf Street in Zone Residence A with regard to Section 5F to allow for 2 single-family dwellings on 1 lot for a temporary period of time to be extended to December 17th, 2021.
Can I get a second?
Second.
All in favor?
Aye.
Aye.
So moved. Get working.
Thank you very
Got
much.
6 months.
Thank you.
and apparently your neighbors don't care anyway.
Yeah, nobody came.
This is more what we're used to.
This is what we are used to. Okay, wonderful. So, next up, the never-ending
This is the
evening.
last one, though, right?
this is,
No?
well, we have to vote.
To
Gotta
hear the
withdraw
appeal
this.
of Select Trucks of America LLC doing business as Select Trucks New England, 2477 Deerfield Drive, Fort Mill, South Carolina, for a special permit from the Shrewsbury zoning bylaws under Section 6, Table 1, to allow the sale of large trucks and equipment upon the property located at 3 Commerce Road in the Limited Industrial District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 54, Plot 007000. Good evening.
Good evening. Madam Chair, members of the board, Richard Ricker, I represent Select Trucks. With me is the local manager, Mike DeLong, who is the manager of Select Trucks of America at the property next door to this, which actually is part of the same property now, but the property's being subdivided, split into two. And they're moving from over here where Tri-State Trucks Center is. They're moving up on the hill behind. You've probably seen the big stone wall there that goes up the hill. Commerce Road is right here. They would enter from Commerce Road and come into this rather large lot and put their facility right here. What they do is they sell large tractors, tractor-trailer type of vehicles, and large equipment. It is a special permit because in this neighborhood, this is in keeping with the neighborhood. As you are undoubtedly aware, there are an awful lot of trucking terminals and truck-related businesses in this particular vicinity. Just up the street, you have Flynn's Truck Stop and all of the parking areas for tractors and trailers and things like that. This is, as I say, it's a very large lot. It's been leveled. As you can see from the plan in front of you, we're using about half of the lot for this new facility. This would be a brand-new building for select trucks, and they would move, as I say, from the other lot up to this one. So I would suggest to you respectfully that there would be no nuisance whatsoever. This is in keeping with the neighborhood. It's a use that is common to this neighborhood. We've already been to the Board of Selectmen. They did approve the license change over to this location. If you have any questions.
I just
Thank
have
you.
one question.
Sure.
That, like, see, Commerce Road, like that cul-de-sac at the end, is that all businesses
Yes,
surrounding it?
it's all businesses. In fact, yeah, it's all businesses. You've got trucking companies up here. You've got trucking parking lot, business and parking lots over here. Up over the hill, you've got United Rentals on the other side. You've got Tri-State Truck Center here, over here.
Yeah, I'm familiar with that. I was just wondering on that cul-de-sac. all
Yeah, the
those
whole
different
cul-de-sac
lots
is
that-
commercial.
Yeah.
Yep. The church is beyond there.
Comments, Mr. Mulcahy?
It certainly looks, sorry, I'm just sort of looking at Google Maps too. It certainly appears to be a use in keeping with the neighborhood. I don't really see any issues at all. One thing I was trying to figure out was, do you have any plans for what's going to go in the prior location or no? I guess that's a separate lot now, right?
They're using that. It's a very crowded spot right now, and this is a move to really alleviate the crowding more than anything over there, because they need better maneuverability. They're just crushed.
Yeah, no, it's very tight, it looks like. So,
Tight.
yep, I know all I need to know.
Okay, Ms. Cosette?
I see in our comment letter from Ms. McAllister that this project, it does require review by an outside consultant, and that the appellant has submitted
did
the
submit the-
required fee. I think,
It
go ahead.
It is under review.
Yep. So I just wonder if we want to make sure we have a condition in case that peer review continues beyond what the fee.
We have the letter in your folder, and I apologize to the applicant. I'll send it to you. We recently got it, and
Okay.
Okay.
it was my oversight, so I do apologize on that. There are no comments, essentially, and I would ask the board to take a look. You're welcome to condition it.
I'm just wondering if the special permit should have a condition that, even though the appellant has done everything that we're asking currently, if the peer review must continue beyond the fee that they've already paid, they'll, of course, agree to pay any additional fee.
I think it's
We
done.
have to
So
go
it's-
that far?
I think it's
So,
done.
yeah, the process is
Oh, it's
is
complete
now.
Oh, wonderful.
Yes.
Okay, I
So
did
now
not-
that the
I
letter
saw it
has
was
been
ongoing.
issued, and again, it was really for the board to just have in review.
Okay.
It's really an administrative procedure to ensure that there's necessary review that staff.
If I could
It's
also
already
add,
done.
it also allows us to use that report for administrative review for the planning board if they have any
Wonderful.
questions for us.
Okay,
So-
when you do your site plan review
If,
anyway.
if there is an administrative site plan review, which I think it'll be administrative.
Okay, great, I have nothing.
Okay, Mr. Nesbit?
Nope, I'm good.
Good.
Mr. Fullen?
Good.
That was a good, okay, thank you.
Just had one very quick question.
Yep.
On the satellite photo here, I just see that there's what appears to be a wetland. Is that impacted at all by this?
The wetland is made by us. It's a shared wetland. It is a detention basin that actually comes from my property over at the United Rentals site. We share that wetland as part of our stormwater retention program between the three properties there.
Okay, so that's fine.
Yep.
Got it. Great.
This is a public hearing, but there's no one else in the public, so I think we're good on
Mike,
that.
you want to say
Motion to
anything?
Do we have to
close.
vote? Do we have to open
I
it and
support
close
this,
it?
I support the president.
I think we need a motion to close this hearing.
Yeah, we said.
Motion to close.
Can I get a second?
Seconded.
All in favor?
Aye.
So moved. Can I get a motion, please?
I make a motion to approve the special permit for 3 Commerce Road in the Limited Industrial District for Section 4, Table 1, to allow the sale of large trucks and equipment.
Can I get a second?
Seconded.
All in favor?
Aye.
Aye.
So moved.
Thank
Thank
you.
you very much.
Thanks.
Okay,
I didn't realize we were the last, but apparently we are.
we have a couple,
Shut out the lights in the hall on your way out.
Thank you very much.
We have
Aye, thank you.
Have a good night.
Oh, yeah, we do.
we have to withdraw.
Don't
Forest
close it yet-
Avenue?
Quite yet. Two withdrawals.
151
We have two
Hartford
withdrawals.
Turnpike and 7
Okay, so I have to read it into the record. Next hearing is to hear the appeal of Bees LLC, care of Mark Seppi, PMI Worcester, 172 Shrewsbury Street, Worcester, Mass., for special permit to the town of Shrewsbury zoning bylaws under Section 4B to remove and replace a mobile home trailer on unit number 13 upon property located at 151 Hartford Turnpike, Shrewsbury, Mass., in the Commercial Business District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 52, Plot 088000. I believe, Ms. McAllister, we've had a formal request for a withdrawal.
Withdraw without prejudice, pending, or due to the fact that they will be coming back before the board with a more comprehensive application, due to matters that weren't covered in the review for this permit.
Okay, thank you. Can I get a motion?
motion to withdraw without prejudice the special permit for 151 Hartford Turnpike in the Commercial Business District.
Can I get a second?
Seconded?
All in favor?
Aye.
Aye.
So moved. Okay. Last and final
Yes.
hearing
Yeah.
is to hear the appeal of Michael Perdoni, 13 Forest Avenue, Shrewsbury, Mass., for variance and special permit to the town of Shrewsbury zoning bylaws, Section 6, to allow for overnight storage, parking, or garaging of commercial vehicles of more than 15,000 pounds gross vehicle weight upon property located at 7 Forest Ave in the Limited Business District. The subject premise is described on the Shrewsbury Assessor's Tax Plate 57, Plot 083000. Ms. McAllister, this is a request for withdrawal as well.
Correct, without prejudice.
Can I get a motion?
I make a motion to withdraw without prejudice the special permit and variance for 7 Forest Avenue in the Limited Business District.
Can I get a second?
Seconded?
All in favor?
Aye.
So moved. Whew. Can I get a collective amen?
It's a public meeting.
I think that went quicker than I
It's
thought.
actually one thing you cannot do.
Oh, yeah, you can't.
The First Amendment,
Oh, sorry.
withdrawn.
Withdrawn. Request to withdraw. Okay.
Amen, withdrawn. Without
Withdraw
prejudice.
without prejudice?
You attorneys. Everything's complicated. Oh, my heavens. Okay. Can I get a motion to close the meeting of the Zoning Board of Appeals?
Motion to close.
Can I get a second?
Seconded?
All in favor?
Aye.
So moved. Thank you.
Good night, everyone.
Here we go. It's for you.
Okay. Okay.